like to introduce the court to Michael Lee, a new lawyer with her firm, formerly of the Texas Bar. And with that, I'll sit down and get out of the way.
He is licensed in Tennessee now?
Yes, sir. Yes, sir.
Okay, good. Well, welcome then. I assume he's going to be presenting an argument, or who will be presenting an argument on this side?
Yes, sir.
This, okay. Ms. Harrell will go first. You would go first. He will be doing the rebuttal. How are y'all going to divide that?
Your Honor, I will be presenting first during our allotted 15 minutes, and then Mr. Lee will present after me. I expect my argument to take about 8 minutes, okay. And then he will proceed with 5, and we would like to reserve 2 for rebuttal, please.
Okay, that'll be all right. Okay. Thank you. You may proceed.
Good morning, Your Honors, and may it please the Court. My name is Emily Harrell on behalf of Kara Trentham, and may I first just say that I'm privileged to be appearing before you for the first time. Appellants filed a joint brief in this matter, so as we just discussed, I will be presenting on the first issue in appellant's brief, and Mr. Lee will be presenting after me on the second issue in appellant's brief. The underlying facts of this case involve a dispute about a land sales contract in which appellees promised to convey real estate that operated as a campground business to appellants for a series of lump sum payments, which made up a down payment, and in addition to monthly payments towards a total purchase price of $1 million. The issues on appeal, however, regard the trial court's ruling on appellee plaintiff's complaint in appellee's favor and the sua sponte dismissal of appellant's counterclaims, which was starkly antithetical to Tennessee precedent and resulted in a windfall to appellees who regained title to the property while also allowed to retain payments made by appellees in the amount of $126,404 and a $600,000 insurance payment, which was the result of a fire on the property, and appellant submit was agreed to be a credit towards the purchase price. That is in total $926,404 towards the total $1 million purchase price.
At the time that payment was made, was there any type of supplemental or amended agreement between the parties?
No, Your Honor. Nothing formal, nothing written.
Who was actually insured? Who was the actual insured at the time?
The appellants were the insured. They received the payment.
And they actually turned it over to?
Yes. Well,
the appellant.
The appellants.
And they actually turned it over to the appellees.
Yes. So the total insurance payment was a $500 property payment, and appellants hired a public adjuster to help get the settlement, and they actually have intervened in this case as a third-party defendant in their first call. So they were entitled to some proceeds, and that's why they intervened as a third-party defendant. But the $500,000 payment was turned over to appellees, and I believe put towards their remaining mortgage on the property, with about $10,000 remaining that they kept.
Was there any credit between the parties as to how this will be applied for the next installment or for so many installments, anything like that?
No, Your Honor. There is, appellants have submitted that there was a conversation between Jerry and Danny Keys about how the payment would be put towards the purchase price, but there is nothing formal in writing about how the payment structure would be amended or anything such as that.
Okay. All right, you may proceed. I'm sorry.
Appellants filed appellees filed their complaint on June 12th, 2020, alleging that appellants failed to make the payments pursuant to the contract. Appellants, with leave of court, filed an amended answer and counter complaints alleging 7 causes of action, including fraudulent inducement, breach of contract, libel of title, intentional interference with contract relations, and other claims. Subsequently, on November 29th, 2019, the appellant's attorney was allowed to withdraw from representation. On April 8th, 2022, appellees filed a motion titled Motion for Return of Realty, asking the court to order that appellants are to vacate the property, alleging that they had defaulted under the contract for failure to make timely payments. among other things. The motion was not brought pursuant to any specific rule of civil procedure. On May 6, 2022, Mr. Trentham, acting pro se, filed a defendant's motion for judgment, asking the court to enter judgment, quote, on plaintiff's claims in the above-mentioned case in defendant's favor. Mr. Trentham does not ask the court for relief regarding appellant's counterclaims. A hearing was conducted on appellee's motion for return of realty on May 13, 2022. Appellees and their counsel were present. Mr. Trentham appeared pro se, and Ms. Trentham was absent, having not received notice of the hearing. There is no transcript of this proceeding, and the order is utterly void of any facts to support the trial court's ruling that appellants breached the contract and must vacate the property. The order stating only that the defendant, Jerry Trentham, by his own admission, at the hearing breached the terms of the contract for the sale of real estate.
What I was trying to figure out, though, is based upon admission, what did he actually say? Is anything in the record as to what that admission was?
No, Your Honor, and that is exactly the point. The order failed to include any type of specific finding as to what the breach was. It only says that by his own admission. That is the only statement of fact that you can find in that order. And that's important because the court fails to find that the appellant defaulted under the contract by failing to make the monthly payments, which is the only instance of default which would result in reversion of title to the property under the contract. That order also purported to be a final order, and it says all issues in this matter are adjudicated, and it is a final order. Both Mr. and Mrs. Trentham retained new and separate counsel following the order, and during a hearing on Mr. Trentham's motion to stay or alter or amend, counsel had to directly ask the court for clarity regarding the appellant's pending counterclaims. However, the court just reaffirmed that the May 25th order had adjudicated all the claims, and it had heard all proof in the case. There is Tennessee precedent regarding sua sponte dismissals and grants of summary judgment, which the trial court here utterly failed to abide. Because there was no dispositive motion pending, no motion to dismiss or motion for summary judgment pending, the court's action when it dismissed the counterclaims was it acting sua sponte. The Tennessee Supreme Court in Huckabee v. Spangler said that although trial courts do have authority to sua sponte dismiss a complaint, such practice is not encouraged and that it is subject to scrutiny on appeal. For instance, in Carnett v. PNC Bank, the Court of Appeals at Jackson vacated the trial court's sua sponte dismissal of plaintiff's complaint, citing that there was no dispositive motion pending. The trial court offered no reasoning illuminating its decision to dismiss the complaint, which left the Court of Appeals with a sparse record with which it could have afforded the trial court any deference. It also noted the effect that sua sponte dismissals have on pro se litigants specifically, saying the trial courts are encouraged to provide sufficient explanations in that circumstance. Lastly, in Just v. Nelson, a decision authored by the late Honorable Judge Susano and joined by yourself, Judge McClarty, the court set a high watermark for what is expected of trial courts when engaging in sua sponte dismissals. The court there found that even when the trial court indicated its willingness to dismiss the complaint and allowed both parties to file briefs on the issue, the court's lack of an adequate justification in its order was reason enough for this Court of Appeals to vacate the judgment of that trial court and remand. Appellants are respectfully asking that this court vacate the decision of the trial court and remand for further proceedings on plaintiff's claim and appellant's counterclaims. And I'll hand it over to Mr. Lee. Thank you for your time.
Thank you. Mr. Lee.
Good morning, Your Honors. May it please the Court. My name is Michael Lee. I represent the appellant, Mr. Jerry Trentham. I'd like to thank Ms. Harrell for explaining how we got here and why that procedure was unfair and prejudicial to the appellants. It also resulted in a record that's incomplete and unclear, and we want a record that's complete and clear on appeal to facilitate appellate review. But in addition, complete and clear records also reflect that the parties and the issues were dealt with appropriately in the trial court, and that's just not the situation here. We have multiple counterclaims that are contract-based. In addition, there were affirmative defenses that were contract-based as well that the trial court did not reach. The appellants didn't have the opportunity to conduct complete discovery, to identify appropriate evidence, to put on proof. Nonetheless, the trial court dismissed those counterclaims and those affirmative defenses without notice. As a result, the contract-based defenses and counterclaims that the appellants raised were not litigated, and we don't really have any distillation of what issues might have been able to be presented because the trial court didn't elucidate any findings on the matter. And for that reason, appellants in an abundance of caution have been forced essentially to present those issues for appellate review at this point. Now, the court might be wondering, why do we need to talk about contract-based issues, contract interpretation, whether the contract was vague or ambiguous? Because the trial court's sua sponte summary dismissal of the affirmative defenses and counterclaims should be reason enough to warrant remand. But the contract itself does bear some explanation of why this case really belongs in the trial court still. And it's that the contract that we're talking about, as Ms. Harrell explained, is a purchase and sale agreement. We've got payment of money for transfer of ownership of real property. Payment terms in the contract were for a $200,000 down payment, broken down as Ms. Harrell explained, and the remaining $800,000 would be subject to an 8.5% simple interest. Simple interest is not defined anywhere in the contract. As Your Honor, Justice McClarty was discussing, the contract doesn't provide for how the large insurance proceeds lump sum payment was to be applied towards the purchase agreement. The $600,000 came at a time when the appellants were still in the middle of their 60 monthly payments. Of course, there are situations we can conceptualize of such a large lump sum payment there ending up dwarfing the amount owed under the contract. The contract doesn't speak to how to resolve that kind of a situation. So in that kind of a situation where the contract has some vagueness or some ambiguity regarding the payment terms, what needs to happen is factual development at the trial court so that the trial court can enter findings as to how to interpret the contract to either support the mutual understanding of the parties in the contract so that the contract stands, or find that the contract is just unenforceable. Now, what the situation would have been here, we can only guess. We don't know what the contract says or what the trial court's findings were because it didn't provide any. And for that reason alone, again, we have remand being necessary here. In addition, the trial court's findings of fact regarding the contract are only that there's some nebulous admission as to a breach of contract. Throughout the record, you can see that the appellants maintained adamantly that they were in compliance with the payment terms. Obviously, appellees would dispute that, but that's all that we have is an allegation that results in a dispute that was not administered or adjudicated below. So we can only guess at the appellate stage what should have happened. And the only outcome that would resolve that situation appropriately and fairly would be remand. We have two possible scenarios. One is that the contract is vague or ambiguous, and that requires elucidation at the trial court, so we need remand. Alternatively, if the contract is clear and unambiguous, then we have a question of why the trial court ordered reversion of the property when there's no finding of fact regarding a breach of payment terms, when that is the only breach under the terms of the supposedly clear and unambiguous contract that would warrant remand. Or sorry,
Excuse me for interrupting,
Yes,
counsel. As I understand, if I'm referring to the proper order, one entered May the 24th of May 25th of 22. By his own admission at the hearing, the defendant had breached the terms of the contract for sale. Is that a finding that the trial court made, and how would that impact?
On its face, it's a finding by the trial court, but that finding doesn't specify any relation to the breach of the payment terms. There are various clauses under this contract, including a requirement to maintain liability insurance, for example. There were allegations that insurance wasn't maintained on the property, and the reason why was because after the fire occurred, there was a burned building that remained on the premises for insurance adjustment purposes, And while that structure remained on the property was deemed uninsurable in that sense. And so,
Making a ruling on as far as once the property became uninsurable, did the court make any rulings on that issue?
there were no rulings on any of these issues. And all of that really underscores the point that these issues weren't properly litigated, that we would have litigated these questions and these issues if we had been able to conduct the discovery on the affirmative defenses and counterclaims based on the contract that were raised, and for which no notice was given at the trial court that the court would be considering those issues for a final judgment.
Thank you.
Thank you, Your Honors.
Yes, sir. Good morning.
And please, Jonathan Hamby of the Cumberland County Bar. It's good to see you again. I've been in front of everyone except the Honorable Judge Davis. Nice to meet you. If it please the court, I don't want to spend too much time on the insurance issue. I consider the insurance issue a bit of a red herring. At the time the insurance issue became involved, it was a mere 4 months after this contract was signed that the sellers filed their sworn termination statement. Pursuant to the contract, if there's a default in the terms of any of the payments as set out in paragraph 2 of the contract, the sellers can file a sworn termination statement, and that will result in a reversion of title. They filed said sworn termination statement, and the property was not given back to them, hence the litigation. They had to file suit to back up their sworn termination statement that they had already properly filed. In the sworn termination statement, from right out of the gate, 4 months after the contract was signed, the sellers state under oath that they failed to make the payments and lump sum payments as required under the contract. Paragraph 2 of the contract lays out the consideration for the contract. I quote.
This was after the fire?
No, Your Honor. This was
fire.
right out of the gate, correct. This lawsuit was filed in 2020, was not ruled upon until 2022.
Is this in the record? And if it is in the record, why did not the trial court make reference to it?
Is what not in the record?
What you're presenting to us, the statement that the sellers filed.
Yes, Your Honor. It was filed as Exhibit A to the original complaint to get the realty returned.
Okay. But the trial court did not make reference to this in the order? I did not see it in the order unless there's something else that I have overlooked.
As we've seen, the trial court's order talks about various and sundry violations and defaults, and the order talks of the seller, the buyer, Mr. Trentham, by his own admissions, he's breached the contract. Does the order speak specifically to the sworn termination statement? No, it does not. The sworn termination statement filed by the sellers a mere 4 months after signing the contract states that the lump sum consideration payments were not paid. If you look at paragraph 2 of the contract, the consideration, it's interesting how they diced it up. The consideration for the contract were certain lump sum payments. It was a total, I believe, of $1 million to be paid a substantial amount on this date, a substantial amount on that date, a substantial amount on this date. 4 months after signing, they filed a sworn termination statement stating that the payments, including the lump sum payments, were not paid, and therefore the buyers were in breach. So they file their sworn termination statement. They attempt to get the property back to no avail, hence the litigation, and they have to file the complaint. I cited a case in my brief. Lack of consideration in a contract renders a contract null and void. And by the terms of this express contract, the consideration were these lump sum payments to be paid a couple of months out from each other. Throughout the litigation and entirely in the record, the sellers have stated that those weren't paid. There is a dispute as to an alleged cash payment. The buyers alleged that they paid the sellers not appropriately the right amount, but this $93,700 cash payment. The only record of that is a handwritten receipt that was filed by the buyers as an exhibit when they set the stage for a final hearing in this matter. I say set the stage for a final hearing because by filing his motion for judgment, when they went to court in 2022, their counterclaims had been on file for almost a year. An answer had been filed by my sellers, my clients, to that, denying that they were meritorious and asking that they be dismissed. The buyers set the stage for a final hearing by filing his motion for judgment on the claims. He was acting pro se at that time. I suppose one could consider that a notice of final hearing. We are going to court. I'm asking for a judgment on all the claims, my counterclaims, their claims. He asked in the motion that the original complaint be dismissed. He asked for a ruling on the pending counterclaims that had been pending for almost a year. The case that was cited, the Just case that was cited in their brief, entirely distinguishable. That case...
Let me stop you right there before
Yes,
you get into the Just case. The problem I see with respect to the counterclaims is the trial court's order just does not address them at all. I mean, it is a pretty bare bones order which just says Jerry Trentham admitted he breached the contract, and so the realty is being returned.
I agree.
How can we review that, the counterclaims, if they weren't even addressed?
I agree the order is not as fully fleshed as it should be. I wholeheartedly agree. However, I would ask respectfully the court to look at the entire record. I don't consider that fatal on appeal if there's proper facts in the record that this honorable court could look to support the trial court's ruling. And I think you can. In the transcript that was provided in the record on the motion to set aside the final order, the trial court indicates, I had everything before me that day. We were here on a motion for judgment on the claims. Although acting pro se, the buyers appeared, they filed a motion, they filed exhibits, he was able to testify under oath. He had his day in court, and he was able to present it. The trial court indicates that in the transcript of his ruling, that I had everything before me that day and I heard it all. He had his day in court. This was not a surprise or a sandbag, as they say. If I've answered your question, if I may talk about the Just case is distinguishable. In that case, the trial court dismissed the claims, and then 30 days after that dismissal, an amended complaint was filed. And the trial court did not give a hearing. The trial court just said, file briefs and I'll consider it. And then after that, it was dismissed without a hearing. Distinguishable from the Just case is the case at bar, where the buyers filed a motion for judgment on everything. They came to court. They filed exhibits. He testified under oath. That set the stage for a final hearing. And the trial court does come out and talk about how I had everything before me that day. And again, he got to testify and file exhibits.
Just to make sure I understand correctly, though, that Jerry Trentham appeared, but his wife did not. Is that correct?
That's correct.
Okay.
That's correct. And that's moving on. My third issue raised in the brief is that Mrs. Trentham basically slept on her rights. And this was a case in the Chancery Court. And equity aids the vigilant, not those who sleep on their rights. She was given proper notice that her attorney was withdrawing. The trial court put down an order that said these folks might settle this case. I'm going to give you 30 days, and if it doesn't settle, then I'm going to grant the withdrawal. It did not settle. Obviously, we're here. And the trial court put down an order allowing that attorney to withdraw. That order was mailed and emailed to Mrs. Trentham pursuant to the certificate of service. Months and months later, 4 to 6 months later, the motion for judgment filed by the purchasers is filed, and a hearing is set, a notice of hearing is set. All of these documents filed in the trial court were served on Mrs. Trentham to her last known address. Fair or not, Rule 5...
Court's order that the court enter a default against Ms. Trentham?
No, Your Honor. There's no order of default, so to speak. Throughout the stages from her attorney's withdrawal to this date with the final hearing on the motion for judgment, she was mailed every document to her last known address.
He considered the case continuously as one case then?
Yes, Your Honor.
ruling applied to both parties?
Yes, Your Honor.
Okay.
Almost as if Mr. Trentham was presenting the case for Mrs. Trentham as well.
Okay.
Any payment that he would have made, she would have made and taken credit for. They were the buyers together. They were in the basket together. Fair or not, Rule 5.02 of the Tennessee Rules of Civil Procedure says on a pro se litigant, service is proper to their last known address. Mrs. Trentham never informed the clerk or the trial court of a new address. She never made an appearance pro se. And no attorney ever made an appearance for her. The sellers were not required to wait around or to try to call her, to try to get her reserved, to try to hire a process server or hire an investigator to find out where she is. She's already engaged in the litigation. She's aware of this. She's on notice. So to say that she was defaulted upon, or to say that she was surprised that this happened, just isn't accurate. She was engaged in the litigation, and she knew or should have known that she had a duty to inform everyone of a new address if she wanted notice. And again, that hearing was not held until, it's either 4 or 6 months after the withdrawal of her attorney is when they finally come to court for that hearing. The second issue.
I want to ask you about,
Yes, Your
just
Honor.
from a fundamental fairness point of view. This contract was for the purchase and sale of the property for $1 million. And at the end of the day, if the trial court's order stands, your clients walk away with the property and with $900 and something odd thousand. How is that fundamentally fair?
We dispute the facts about the amount of money.
Okay.
And that's disputed throughout. 4 months after signing the contract, they file a termination statement that says, hey, the consideration's not even been paid. You've already defaulted pursuant to paragraph 2. Land sale contracts are fundamentally unfair by their very nature, but they've never been outlawed by our Tennessee Supreme Court. Therefore, they are enforceable as written. And as written, paragraph 2 of this contract states that as consideration for the contract, these lump sum payments shall be paid. The sellers allege that never happened and immediately exercised their rights to terminate. When they were not given the property back is when they filed suit. During the litigation, the buyers played a bit of a cat and mouse game by making some payments and trying to appear that they were in compliance with the contract. Whereas in reality, this case is about square one. 4 months after signing, they're in default and they won't give the property back. Throughout the litigation, and then, it's a year into the litigation before the fire happens and the insurance is paid.
But you see, our problem, though, is that in the trial court's order, he don't make findings to what you presented to us.
He has, the trial court has made us all do more homework than probably necessary. We've all had to dig through the records to see why. I would submit that if we look at the record, the why is in there. The trial court had a hearing on the merits. All the claims were filed. Everyone was on notice, and he found that the buyers did in fact breach. I do agree with the bare bonesness of the order. We cannot get past that. But I would ask.
It's our favorite thing to do, to go through the record and create the reasons why the trial court did what it did. We love doing that.
I understand, and we loved doing it briefing, I'm sure. But I would submit that respectfully, it is there. That they exercised their rights right out of the gate when they thought they were in breach. And an alleged cash payment with a handwritten receipt for $93,000. A lot of it doesn't add up, and a lot of the trial court's reasoning does add up, but you do have to read through the lines. I'll give you that. Is a remand the proper remedy for a poorly drawn final order? I do not believe so in this instance. Kind of a side note, I'm running a little short on time, but if your honors remember, and if it is in your record, there was a motion to, there were motions filed in the appellate court asking for a stay of the ruling. These buyers are gone from the property, and we both filed affidavits in support of the motion for stay, and we asked for a denial of the stay. this honorable court denied the stay, and so as a result thereof, my sellers got the property back. In those affidavits, my sellers filed that when they came back upon the property, everything was abandoned, things were taken that shouldn't have been, the pool was drained, there was property damage and all that. So is a remand the proper remedy in this? So they get to come back upon, now that my sellers, half a year later, have finally gotten their property back, have made some improvements, have gotten back into the swing of things. This is a resort like a campground. Is a remand proper to reconsider all that? I would say no. Briefly, I would state that asking this court to reinterpret the contract is an issue that was not raised in the trial court. It was not raised in the pleading, and therefore I would say it's waived on appeal. I've got a few seconds left if any of your honors have any questions.
I hear none.
I really appreciate your time.
Thank you very much, sir.
Thank you.
Your rebuttal?
Thank you, Your Honors. I'll speak first to the issue of consideration brought up by counsel. There's a dispute about the down payment. There's a dispute about every payment in this case. But I do know that it is in the record attached to a motion filed by appellees, the motion for return of realty deposit slips that show monthly payments of $6,000 and some dollars being deposited that add up to $97,000. So, and that's attached to appellee's own motion. So I don't think there's a question that there was ample consideration for this contract. Secondly, the defendant's motion for judgment, appellee insists that there was a request for relief on the counterclaims, and I implore the court to look carefully because you will not find the word counterclaim in defendant's motion for judgment at all. There was no request for judgment on the counterclaims, which, so the court did not have that issue before it at its May 13th hearing. And as far as the explanation given by the trial court, Your Honors are right that the record, there are no findings of fact. And it's worth noting that even when the trial court was given a second opportunity to justify its decision to sua sponte dismiss the counterclaims, when it ruled on its Mr. Trentham's motion to alter or amend, which is the July 20th order, it's still absolutely void of any facts to support its decision. And although the court says I have all issues before me that day when it's speaking about the May 13th hearing, it says I heard all the issues. It's also worth considering that if it heard all the issues, including evidence and argument about the counterclaims, then why wasn't it in that order? And also, I'll just mention, Your Honors, that as far as destruction of the property after this appeal was filed, appellees failed to consider that appellants also constructed 12 cabins while they were the owners of the property, so the property has been largely improved. And I'll speak just quickly, Your Honors, to the issue regarding Ms. Trentham specifically. I'm sorry, Your Honor, did you have a question?
Time is out.
This says I have 30 seconds.
Okay.
If you don't mind.
Okay. It does not. It shows a red light to me.
It says stop. You are correct, Your Honor. I apologize. Thank you for your time.
Okay. I want to thank the attorneys for your presentation. Your case has been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. The attorneys may be excused.